God bless America. Hello, everybody. I am the Talk Radio Protege, and this is the Protege program. Happy Friday, everyone. I'm so glad that the weekend is finally here. All that's standing between you and the weekend is this video about the Supreme Court cases that are upcoming for the next session of the court. Now that Neil Gorsuch is firmly in place as Justice Scalia's replacement, it's time the Supreme Court gets into gear hearing some of these cases. There are a couple of very important ones to consider, some that I don't have as much of an opinion about, but we're going to talk about those at this time. So this story comes from Bloomberg and lists I think it's 6 cases that are of importance coming up. I took a whole bunch of notes about what I thought about these cases, and then I left them all behind, so I'm doing this without a script. Here we go. Let's get past the video. Let's get past that. Let's get past the picture and get on to number 1, class actions, October 2nd. This case is about class action lawsuits between labor union members and their employers. Now, as a guy that thinks of himself as pro-business, I generally disapprove of labor unions in general. Their Democrat Party fundraising hack jobs. So when it comes to whether or not labor unions have to abide by arbitration agreements that they agree to, I kind of think that this ought to be a pro-business decision. Maybe we ought to rule on the side of the employers. But let's see. Yeah, if this law that was passed in 1925, which I didn't take the time to look up because I'm not terribly concerned about this case, but if this law does what companies say it does, then the decision will need to be made in favor of the companies. Let's go ahead and move on to the next one, gerrymandering. Now, I, for one, don't think that the Supreme Court hearing these out on a case-by-case basis is going to fix the real problem with gerrymandering. I would like to see an amendment to the Constitution passed that said something to the effect of congressional districts will be drawn in the simplest geometric shapes possible to do whatever it is that we have to do with the rules according to redistricting, which is what the problem is with gerrymandering. That I think if I understand congressional districts, they're drawn such that each district has the same proportion of the population in it, such that the number of representatives that state gets is correct. And outside of that, I don't really know. So I would like to see something different done with gerrymandering besides just doing whatever it is that they're going to be doing with this case. In this case, it's Democrats suing Republicans over a redistricting issue. So tribalistically, I'd like to see the Republicans win this one, but I think that this Supreme Court case is going to be, or rather, is largely unimpactful as to what the root problem is with gerrymandering. So let's move on to the next one, voter purges. This is a little bit interesting. I tried to track down the law that they say, this 2002 law. I did finally manage to track it down. It's called the Helping Americans Vote Act. HAVA was passed in 2002. It's 83 freaking pages long. So good luck trying to find out where it is that Ohio might be going wrong with this one. But when it comes to purging the voter rolls, there's a question you have to ask when it comes to, there's a question that you have to ask the opposition when it comes to purging the voter rolls. Why shouldn't we purge the voter rolls? Now, the way that the state of Ohio does it is if you haven't voted in 6 years and you don't confirm your address, you're purged from the roll. So, a dead person, the dead people are the people that we're most concerned about purging, that conservatives are most concerned about purging from the rolls, because we're in a habit of just not purging the rolls, so dead people are left in the rolls, and those and their votes can be abused by the dishonest people that want to abuse the voter rolls. So, that being said, Republicans would like to purge those people from the rolls, and the Democrats are always opposed to purging the voter rolls, especially of the dead people. And they say it's about voter suppression, because you might accidentally purge someone from the roll who isn't voting, and then they decide one day that they want to show up to vote. And responsible citizens, they vote more than once every 6 years anyway, and they do what needs to be done to make sure that they can vote. Or if they don't think they've done what's necessary to vote, they don't go out and try to vote. So it's not a voter suppression thing. It's a voter fraud thing that we're not doing often enough, in my opinion. And then we get to this one. This is a big deal, and I took a whole bunch of notes on this one and left them behind, so I hope that I actually say everything that I meant to say. Now, this is the, should a bakery should a bakery be forced to make a cake for a gay wedding if the owners object to gay weddings on religious grounds? I don't think that's the conversation that we need to be having in regards to this case at all. This is a case of, should a person that wants to be engaged in commerce be allowed to force an individual who does not want to be engaged in commerce to engage in commerce? This is a question of commerce versus private property rights. I have a question for all of you watching. Does a store owner or does a private individual who owns a business, do they have an obligation to sell their wares to anyone? The correct answer is no, and the reason is this: when a private individual or when a business purchases stock to put in their store, they do not have to sell it. They can do whatever they want with that stock because they've bought it and it belongs to them. They don't actually have to sell it. If I tomorrow decide I'm going to start selling keychains, and then I go out and buy a whole bunch of keychains, and then tomorrow decide that I don't actually want to sell keychains, I'm not ever under an obligation to sell those keychains that I bought. It doesn't matter how many I purchased. It doesn't matter how much work I put into selling those keychains, how much prep work I put into opening the business. That doesn't matter. An established business is only different in context. The context is this business has been open for a while. They've been selling to a lot of people. They may have even sold to people that under a different context they wouldn't sell to. And now they're being asked openly to violate their conscience by doing something that they believe endorses a lifestyle which they wouldn't, under any other circumstance, endorse. Should that person be forced into engaging in commerce because in a situation where they now do not want to engage in commerce? And I believe, and I think that the law and the Constitution supports me on this one, that the answer is no. Liberty, especially, or the spirit of the Constitution, rather, is that we government should protect individuals from being forced to do things that they do not want to do, or to suffer consequences of people trying to encroach upon their liberties. That's what the First Amendment is all about: freedom of speech, freedom of the press, freedom to assemble. That's all about being able to do what you want. The Second Amendment, freedom to bear arms, is all about the freedom to prevent other people from forcing you to do something that you do not want to do. The Fourth Amendment also comes into play here, where individuals are to be secure in their home from unreasonable searches and seizure. Now, I think that a person taking something of yours and forcing you to accept some form of currency in return would be an unreasonable seizure of that property. If I steal your car and give you $10,000 in cash and say you should just be okay with this, that's unreasonable. By the same token, I don't think the government should effectively hold a gun to the head of a business owner and say, you will make a cake for these people, you will give it to them, and you will accept this form of currency, and you will be okay with it. I don't think that that's okay. I think that we should definitely be siding on the Colorado bakery in this case. I don't think that this is a gay rights versus free speech case. And even if it was, I don't think it's a gay rights versus free speech. I think it's the desire to engage in commerce versus free speech. And in which case, free speech ought to trump the desire to engage in commerce. Not only that, this is not even a big deal in this day and age. Perhaps at one point in time, it might have been necessary to ask the question, should we force this bakery to bake a cake for this couple because no other bakery will? We do not live in a time where that is the case. We live in a time where this bakery will not bake a cake for this couple, so why don't they go to this bakery which will? I guarantee you there's a Walmart in this town in Colorado that will gladly bake a couple this couple a cake, that will not even ask the question, are you a gay couple, to these two people. So because that is the case, I don't think that this is a case that ought to be considered by the Supreme Court. There is not a bakery that holds a monopoly over baking cakes. Therefore, this gay couple can go to another bakery and get a cake. That's my opinion on the matter. I think enough has been said. I think I'm going to go ahead and move on. Cell phone privacy. I don't have a lot of knowledge on this subject. All I really have is the blurb given here from Bloomberg. And from the information that is on this page, I think that the Supreme Court ought to rule in favor of privacy. In this specific case, or the reason that we're hearing this case about cell phone privacy, is that an individual is seeking to overturn his conviction for taking part in armed robberies in the Detroit area because cell phone data was procured in order to prove that attempt to prove that he was guilty. Apparently, probable cause, it does not have to be proven in order to get this cell phone data that was used in this case. So my opinion on this case is that the Supreme Court ought to rule in favor of the individual, in favor of private, in favor of privacy. I think the Fourth Amendment might come into case here, but I think there is a little gray area to be talked about when we live in an age where people readily and nearly without hesitation upload their location to social media dozens of times in a day. Of course, if you're not doing that, if you're not purposefully uploading your location to social media, I don't think it ought to be as easy as it currently is for the authorities to obtain information about your location. Now, this next one, whoops, about dropped my phone there. This next one, I really don't have an opinion whatsoever on. I am not a gambling man. Even if sports gambling was allowed, I wouldn't be placing those bets. I understand that there is some corruption to be concerned about in the area of sports gambling, where being able to gamble on a sport might bring the integrity of the sport into question. But I don't really have a lot of opinion in this situation. If there is a sports fanatic listening that has more of an opinion that can articulate the points against allowing sports gambling or for sports gambling, let me know in the comments. I would love to hear that discussion. So let's go ahead and move on. Now we have the travel ban, and I do actually have the law looked up for this one. The travel ban, first of all, is being blocked by the Ninth Circus over campaign rhetoric. Judges or prosecutors made the case against Trump's travel ban based on words that Trump said before he became president, and also on rumors of words that Trump did not say before he became president. The courts made a judgment not based on the executive order or its contents whatsoever. In fact, there is legal precedent for the president's travel ban, and it's from U.S. Code 8. I'm not going to scroll up to look for the section because it'll take me forever to get back here, but it's in U.S. Code 8. It's in section 11442 or 1148 or something like that. But here it is, section paragraph F. Whenever the president finds that the entry of any aliens or of any class of aliens, so even if Trump wanted to do a Muslim ban, he is permitted under the law to do a Muslim ban. That would be a class of aliens, as long as it was foreign Muslims, it would be a class of aliens that he would be able to deem entry detrimental to the interests of the United States, and may by proclamation for such a period as he shall deem necessary, which means it could be the 1 month or 3 month or however long Trump is proposing, or it could be indefinite, suspend the entry of all aliens. All aliens. That doesn't even give a proviso. That could be anybody. That could be all foreigners. Or any class. Again, any class, no provisos. It could be a religious class. It could be a nationality class. It could be a race class. It could be anything. Or impose on the entry of aliens any restrictions he may deem to be appropriate. Whenever the Attorney General finds that a commercial airline has failed to comply with the regulations of the Attorney General regarding to blah, 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 this is extraneous at this point. But the President can place any restrictions on any aliens or class of aliens up to and including total ban that he desires. This means that the travel ban proposed by Trump is totally constitutional. There's no reason the court should be blocking this. This ought to be a slam dunk case for the Supreme Court. Now, Bloomberg throws onto the end here a little blurb about a couple of cases that the Supreme Court is adding, and there's not a bunch of details. I can just give you a little blurb on what I think about these two. This first one about union fees, the court, most notably one that will determine whether 5 million government workers can refuse to pay labor union fees. I think that a worker ought to be able to refuse to join any union for any reason whatsoever. So I think that the court ought to be ruling as so. I think that's the liberty case to make there. I haven't read a lot about this. It sounds strange. It sounds like a slam dunk case again. Federal job bias law protects against discrimination on the basis of sexual orientation. So far, every discrimination law that I've seen names just about everything under the sun that could be used as discrimination, the superficial things at least, that makes them illegal. There's a lot of policy that I've seen, that says X company does not discriminate based on race, gender, sexual orientation, nationality, religion, yada, 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 yada. The federal government is probably the same. This probably is an open and shut thing. So that is what I wanted to talk about today. There has been a story that has been ignored by the media that I want to talk about, that I've been waiting on details to uncover, but there has just been something else to talk about every day so far. So I might do an extra video. I might do a Saturday video. It's the shooting that happened in the Church of Christ in Tennessee. The first time I went to research it, there wasn't a lot of details, and a lot more of information has come to light since then. So I really want to talk about that. That's coming. I promise. It's in the works. It's gonna happen. But thank you for watching this video. I hope that you enjoyed it and that you'll leave a like and subscribe. I hope you'll come back next week for more content every weekday. There's a new video on my channel. So have a wonderful, fantastic weekend. Have a great evening tonight. And God bless you all.